My name is Munibul Hassan. Today, me and my classmates Andre, Holalini, Rebecca, Veronica, and Oive will be talking about the recovery of compensation for psychiatric injury under the English and Malaysian judicial decisions. This presentation aims to delve into the complexities of recovering compensation for psychiatric injury by examining judicial decisions from both English and Malaysian legal systems, as I previously mentioned. By understanding the legal frameworks and principles, we can gain valuable insights into this area of law. Psychiatric injury is a significant concern involving a range of conditions and symptoms that can have a profound impact on individuals' well-beings and quality of life. Recognizing and addressing the consequences of such harm is critical for ensuring fairness and justice. Throughout the presentation, we will discuss the requirements and considerations for claiming compensation for psychiatric injury in both English and Malaysian legal systems. By comparing and contrasting these jurisdictions, we can identify similarities and differences in how this issue is approached. By the end of this presentation, you will have a deeper understanding of the legal considerations and implications for the recovery of compensation for psychiatric injury. Let's now discuss the outline of the structure of this presentation on the recovery of compensation for psychiatric injury. In the following slide, we will examine how the recovery of compensation for psychiatric injury is approached. We will explore notable cases and principles from each jurisdiction, shedding light onto the legal considerations surrounding the psychiatric injury claims. We will be analyzing different cases. We will gain insights into the factors considered, the requirements for establishing liability, and the principles used to determine compensation awarded. Our objective is to provide a comparative understanding for the approaches taken in English and Malaysian jurisdictions, as I previously mentioned. And by the end, you will have gained valuable insights into the legal landscape of recovering compensation for psychiatric injury in both jurisdictions. Let's now proceed to explore a notable case and principles from English and Malaysian judicial decisions. Before that, let's talk about psychiatric injury and how tort is connected with it. So basically, psychiatric injury refers to the harm suffered by individuals in their mental health. It encompasses a range of conditions and symptoms that can signify impact on individuals' well-being and quality of life. In the context of tort law, psychiatric injury becomes a crucial aspect in personal injury claims. It is important to establish that the harm resulted from an accident or a sudden illness or condition. Let's explore this topic further and understand the implications of psychiatric injury in the realm of tort law. The case of Ellock versus Chief Constable of South Yorkshire Police is of significant importance in the English legal framework. As I previously mentioned, this is the case we will be talking about. It provides key insights into the recovery of compensation for psychiatric injury. Lord Ackner's statement in this landmark case emphasized the requirement of shock for claiming damages. This means that it is not enough to show psychiatric injury. There must also be a sudden and shocking event causing that injury. The Ellock case has influenced subsequent decisions and shaped the legal frameworks for psychiatric injury claims. It has established the benchmark for liability of damages, emphasizing the importance of demonstrating the element of shock in such cases. In summary, Ellock versus Chief Constable of South Yorkshire Police sets the precedent and key principles for the recovery of compensation in psychiatric injury cases, highlighting the requirements of shock as a crucial factor in determining liability and damages. Now we'll be talking about more cases by my fellow classmates. Thank you, everyone.
Good day, everyone. My name is Veronica Angeline. Today, I'll be talking about the English judicial decisions for the recovery of compensation for psychiatric injury based on the common law. The first notable decision involving psychiatric injury was a law and Chief Constable of South Yorkshire Police, which established the damages for psychiatric injury are only recoverable if the harm was brought on by shock. The House of Lords determined that none of the claimants in the case provided the proof necessary to support a claim for secondary victim status. Additionally, this case shows that a successful claim in the future will be founded on first, the claimant's proximity to the negligent event in terms of the time and place. The claimant must have been there at the scene or in the early aftermath, limited to 2 hours as stated in the case of Mac Loughlin. Second, the claimant must have a close love and affectionate relationship with the party who was a victim of the act. Third, the source of the nervous shock. The claimant must demonstrate that he had nervous shock as the result of the awful occurrence or its immediate aftermath. Now we will look into the issue in the case of Alok and Chief Constable of South Yorkshire Police. The crucial issue in this case is, however, is that the growth of secondary victim legislation has resulted in the adoption of restriction based on public policy that restricts the prospects for a successful claim, with the floodgates argument serving as the foundation. A lot of bystanders are being unfairly denied compensation in this case because claims were denied despite the fact that it was unforeseeable that a bystander could suffer a psychiatric injury due to the incident's proximity and gruesomeness. In this situation, there is a conflict between the justification for providing remedies to primary victims. Next is the case of Loughlin and O'Brien case, which established the aftermath test, held that the claimant could be awarded damages for a psychiatric disability or injury brought on by a defendant's negligence, provided the injury was reasonably foreseeable. The House of Lords determined that the person could submit a claim in the instance since the link was close enough and she was present for the immediate aftermath. Locke eventually agreed to Wilberforce's three-part test for secondary victims. That would be the liability test. Furthermore, the Lord Wilberforce and Edmund Davies believed that the possibility of psychiatric harm was not the only need. This is referred to as the liability test. There must be some extra limitations based on the type of person who could file the lawsuit. The stronger the emotional connection, the stronger the claim for consideration. Second would be physical proximity to the accident, which might be close both in time and space, though this could include people who did not witness the accident but came upon the aftermath of events. People who would typically go to the scene, like a parent or spouse, would be within the scope of the duty. Third, how the psychiatric disorder or injury or disability was brought on. Information from a third party was insufficient. The plaintiff had to be personally witnessed the occurrence or its immediate aftermath. So, thirdly, it would be in addition, McFarlane and E. Caledonia developed a reasonable foresight test. The defendant did not owe the claimant a duty of care since the court determined that it would be not reasonably unforeseeable that the claimant would have been in danger despite his belief. A duty of care is only owed in extraordinary situations, such as when the claimant is in physical harm or is a rescuer, as was proven in this case. Even if they experience psychiatric injury as a result, the court will not impose a duty of care on innocent witnesses to heinous acts. This case also demonstrates the requirement for proximity is sufficient closeness or vicinity between the parties, not just reasonably foreseeability. Lastly, an employer has a responsibility to ensure that stress at work does not harm an employee's mental health, but only in cases when the damage is foreseeable. An exemption was established in the case of Barber and Somerset County Council. It states that by implementing specific measures, an employer might protect themselves from liability for employee stress. Next, in Hatton against Sutherland, the Court of Appeal examined three cases concurrently and offered specific guidance on the circumstances which employees may be held responsible for workers' stress at work. Employers can typically assume that employees can do their job because of their helpful guidelines provided by the Court of Appeal. But if there is anything that can be done to help an employee who is struggling, then there might be a duty. Thank you. That's all from me.
Hi, my name is Rebecca. As a continuation of what Veronica has presented, I am going to present the cases related to the recovery of compensation for psychiatric injury and the English judicial decision as well. The range of recovery for psychiatric injuries has been expanded as a result of subsequent cases such as the case of Page and Smith. According to the HOL in this case, Page's illness was recognized as a psychiatric injury. Secondly, Page was a genuine primary victim who was present at the scene and at the risk of foreseeable physical injury. Thirdly, Page was entitled to the thin scar rule, regardless of the pre-existing condition that made him more likely to suffer injury resulting from a single traumatic event. In this case, there is a critical issue in which the position for main victims differs from that of secondary victims. As the thin scar rule is only applicable to primary victims, a secondary victim with Page condition cannot claim under the thin scar rule since he or she must show phlegm and fortitude. There is an important judgment in the case of Stephen Monk and P. C. Errington UK Ltd. that holds that a claimant cannot be the main victim if at no stage will the claimant have believed himself to be at possibility of foreseeable injury. Following in the case of White and Chief Constable of South Yorkshire Police, the court ruled that a claimant can be compensated for injury even if there was no shock. The HOL ruled that no claim could be made since the police officer could not be considered as primary victims as they will never be in danger. The laws further stated that there is no longer any indication that a rescuer is a primary victim and he or she can only file a claim if they are at danger of foreseeable injury. After that, it was established in the case of Bohill and Young that psychiatric injury to a witness who is not linked to the main sufferer is often unforeseeable and distant. The court determined that John Young owed Mrs. Bohill no duty of care because the foreseeability threshold was not met and the injury done to John Young was not distant. This case set the criteria of witness recovery and concluded that a woman who had psychiatric injury following an accident was not entitled to compensation if the damage caused was too distant. Moving on, the Supreme Court ruled in Essex and Whittington Hospital NHS Trust in 2020 that a claimant may receive compensation for psychiatric injury brought on by a medical professional's negligence regardless of if there was no physical injury. This ruling permits compensation for any recognizable psychiatric illness caused by the defendant's breach of duty. The extent of recovery for psychiatric harm in English law was broadened by this pivotal judgment. In summary, the law of torts does not include specific provisions for recovering compensation for psychiatric injuries. Instead, it is founded on common law concepts developed through times by the courts.
Good day, everyone. The question of whether compensation should be awarded for psychiatric injury, particularly when it is not caused by shock, has been a matter of significant debate in both English and Malaysian legal systems. The held in conclusion in Malaysia is that a claimant may recover damages for nervous shock brought on by injury caused by negligence. However, recovery of psychiatric injury, which is nervous shock, for a secondary victim should also be recognized for claim, but the person claiming to have suffered nervous shock must fall into a category accepted by the courts as being entitled to claim. The law in Malaysia related to this issue is far from satisfactory, and there is a need for proper guidelines concerning psychiatric illness problems. The court in Thiruvannamalai, Anaraki Alagiri Pillai versus Dinner's Club denied the plaintiff claim for the ordinary emotions of anxiety as they are not recoverable. The plaintiff must provide that the injury was caused by the defendant's negligence. The law recognized recovery for psychiatric injury, which is never shock, for a secondary victim, but the law in Malaysia related to this issue is far from satisfactory. And there is a need for proper guidelines concerning psychiatric illness problem. According to Malaysian law, a claimant may be awarded damages for nervous shock brought on by negligently inflicted harm. However, compensation for mental harm, which is nervous shock, suffered by a secondary victim, should also be recognized as a claim. Courts as being eligible for compensation. There is a need for appropriate recommendation regarding psychiatric disease issues since the law in Malaysia on this subject is far from sufficient. The plaintiff claim for the common emotions of worry was refused by the court in Thiruvannamalai and Alagiri Pillai vs. Dinners Club case because those feelings are not commensable. The plaintiff must demonstrate that the defendant's careless was the reason for the harm. The law recognizes compensation for psychiatric harm for a secondary victim, although the Malaysian legal framework is woeful inadequate in the regard, and comprehensive and recommendation for psychiatric sickness issues are required. Thank you.
Hi, I'm Hui. Now, let's shift our focus to a legal case that took place within the jurisdictions of Malaysia. Zainab binti Ismail against Marimutu and Anor is a Malaysian case where the mother saw her daughter severely injured by the defendant negligently driving his lorry. The daughter's evidence showed that the plaintiff was genuinely suffering from shock and has given her shock which caused her sick for 2 years after the accident. The court came to the conclusion that the defendant cannot be exempted from liability for shock to the plaintiff on the ground of remoteness. Besides, the relationship here is parent and child, for which there is a presumption of closeness, love, and affections. In this case, the court allowed the plaintiff claim for nervous shock sustained as a result of seeing her daughter knocked down by the defendant lorry and was killed while washing clothes at a standpipe in the side street. This case established that it is reasonably foreseeable that a mother who sees her daughter being run down by a lorry would suffer nervous shock. Hence, the plaintiff is entitled to recover damage. In conclusion, the court developed that damage for nervous shock can be claimed if it is reasonably foreseeable that someone closely connected to the victim will suffer nervous shock. The scope of recoverability expanded beyond the primary victim to include the secondary victim. Thank you.
Hi, my name is Andre, and I'm going to talk about the conclusion. In conclusion, the recovery for compensation for psychiatric injury is a complex area of law that varies between English and Malaysian jurisdiction. In English law, the case of Alcock versus Chief Constable of South Yorkshire Police established the requirement for a sudden and shocking event causing a recognized psychiatric illness in order to recover damages. However, subsequent cases like Page versus Smith have expanded the criteria to include situations where a reasonable, foreseeable risk of psychiatric harm exists, even without a sudden shock. In Malaysian law, the courts have recognized that a defendant's negligence causing a recognized psychiatric illness may give rise to a claim for damages. provided that the defendant's conduct was a significant contributing factor to the illness. Overall, both the English and Malaysian legal framework for psychiatric illness strives to provide avenues for individuals to seek redress for the harm caused by negligent actions, promoting the protection and well-being of those who have suffered psychiatric injuries, but there's definitely room for improvement. And thank you guys. And here is the bibliography. Here are the cases that we have used in our video. And here are the books. And here are the journal articles. Lastly, here are the websites. And thank you for watching our video. Thank you. Bye-bye.